I'm Andy Ramirez for the Liberty News Network. Recently, I attended a hearing by the House Committee on the Judiciary in Washington, D.C. as they addressed a portion of the Patriot Act, the Foreign Intel Surveillance Act, better known as FISA. This was a follow-up to a previous hearing addressing the Snowden issue, where the former NSA contractor revealed information overseas, which is where he remains today. I'm not focusing so much on that for this report as I am focusing on what was stated during the over 3-hour hearing. Now, witnesses for the government included James Cole, Deputy United States Attorney General for the Justice Department, John Inglis, Deputy Director at the National Security Agency, Robert Litt, General Counsel from the Office of the Director of National Intelligence. Now I'm going to start with Judge Gomert of Texas, who actually speaks much later during the hearing.
But isn't it true that that even the NSA can get access to the information gathered by the Consumer Financial Protection Bureau?
It's hard to imagine that could be true, but I would say that we can't pull the telephone numbers from this database under any circumstances other than that prescribed by the courts.
But you're entitled to go, I mean, we've had this debate in here. You're entitled to go on the internet or go to private sources that any private citizen could and gather that information without violating any constitutional rights. Isn't that correct?
Certainly, but if the premise is we would do that to match names, identification, personal information against the telephone numbers, we don't have access to the telephone numbers unless we follow the prescribed rules of the court pursuant to a terrorism and investigation.
But if you can gather the information that a private individual could and couple that with information that only the federal government, we're now learning, is gathering, then it really constitutes a grave threat to privacy.
Moving a little later in the hearing, the following is from Mr. Deutsch of Florida.
Instead, what we've learned is that the FISA court has essentially rewritten Section 215 to say that any and all persons' records may be considered relevant, therefore allowing the NSA to indiscriminately collect sensitive data on all Americans. The fact is, in 2012, the government made 1,789 requests to conduct electronic surveillance. Court approved 1,788. The government withdrew the other. It seems that there may be secret laws, laws not passed by Congress, laws not publicly interpreted by the Supreme Court, but rather secret laws born out of a classified interpretation of the Patriot Act by the FISA court. Is it still the Department's position that the government isn't essentially operating with a secret playbook?
Mr. Deutsch, I don't think we are operating with a secret playbook. There is, again, as we've discussed in many instances in our hearing today, we're not trying to keep them secret. We're just trying to maintain the classified nature of some of these.
Now, Mr. Jeffries, another Democrat, stated that
in terms of the total applications submitted since 1979, there were 33,949 applications submitted. Is that accurate? Of that total number of applications, 490, it appears, were modified. 1.4% of the total number of applications made were modified. But what's even more troubling, since 1979, 11 applications were denied. Okay, so your success rate, your batting average, was 99% of the time that you've applied to acquire information that could possibly include communication from one American to another American.
So you have, from these two consecutive Democrats here that I'm presenting information from, Mr. Deutsch and Mr. Jeffries, the government gets what they want. Now, it was also learned during this hearing that only the government is represented. No individual who they're either seeking wiretap applications or other types of intel surveillance on is represented. So the government goes into this FISA court, which is seen by some as a shadow court, and they get whatever they want. And nobody else is represented. Not the Congress, not the American people, nobody. It's just the FISA court and the Justice Department, NSA, whomever. Now, moving on, Mr. Chaffetz of Utah. He requested a copy of court-provided guidance under the Jones case. I believe this is U.S. versus Jones. and that it be provided to the committee, which Deputy Attorney General Cole denied under a law enforcement sensitive type matter.
Will the Department of Justice provide to this body, to this committee, the guidance on Jones?
That's something we'll have to look into. There's lots of law enforcement.
No, wait a second. I know there are law enforcement issues. I know there are other things. Why would you not provide to the United States Congress, the Committee on the Judiciary, why would you not provide a copy of that guidance for this committee?
If it discloses law enforcement sensitive information and techniques of how we go about fighting crime and finding criminals, then we may not feel free to disclose it.
This is what scares me about what you're doing and how you're doing it. If you knew exactly where I was standing, you telling me that that's not content?
That's not the content of your conversation, no. And other people may
so
see you. If you're standing out in public, any number of other people may see you there.
So, but if I was standing on private property.
This is part of what Jones talks about, is the trespass issue.
And they ruled 9-0 that it was an overstep and an overreach. Do I have a reasonable expectation of privacy on private property?
In general, I think the courts are saying that there is a trespass theory that gives you a reasonable expectation of privacy, depending on whose property it is, whether it's your own or somebody else's, how many other people are there. These are all the types of issues that would go into that.
This next exchange is from Judge Poe. He brings up
the Fourth Amendment doesn't mention national security exception when it comes to the Fourth Amendment. That has been expanded throughout the years because of FISA, because of court rulings, but it's not in the Fourth Amendment. And I think that we should remember that the Fourth Amendment was written because of what was going on with King George III, how he was going into people's homes in the United States, the colonies in those days, and seizing things with his redcoats without a warrant.
The answers from the government representatives who were witnesses were so flimsy it was ridiculous. There's nowhere in the Fourth Amendment, though, does it say that you can do these things under national security. And I'm going to kind of skip ahead here because I want to get to Mr. Farenthold. And Mr. Farenthold of Texas addresses also the Fourth Amendment.
Could you go to the FISA court and argue that you had a right to obtain, say, either an individual's or a group or every American's tax return? Could you argue that with a straight face?
Well, I think
I've got a long list of them, yes or no?
Any individual's tax return, there are separate laws that cover the acquisition of tax returns.
All right, so you could get tax returns. Could you get it somebody's permanent record from school?
If it was relevant to the investigation, you could go to the FISA court and ask.
Could you get somebody's hotel records?
If it was relevant.
Could you get the records of everybody who stayed in a particular hotel at any time?
If you can demonstrate to the court that it is relevant to the
investigation.
Okay.
Could you get you could get my Visa MasterCard records?
If I can demonstrate to the court.
All right. Could you demonstrate? Could you argue with a straight face? You could demonstrate to the court to create a database of everybody's Visa MasterCard, every financial transactions that happened in the country, because Visa and MasterCard only keep those for a couple years.
Mr. Farenthold, that's all dependent on exactly what I'm investigating and what the relevance of the information would be and how it would be used and how it would be limited. All of those have to go into it. It is not a simple yes or no, black or white issue. It's a very complicated
Could you get Google searches? Could you get all those searches I made on a search engine?
Again, it would depend. I'd have to make a showing to the court that that kind of information was relevant to the investigation.
Could you get all Google searches and then come back and say we're going to search them later when we've got that information?
It would depend on the way that I would be able to search them. And again, under 215 of this statute that we're talking about, it's only if I can show that it's related to specific terrorist organizations. It's not for anything.
You get the GPS data from my phones too, probably?
I'm sorry?
You could probably make a good argument for getting the GPS data out of my phones or the mapping software I use on my phones too.
Again, there's great limitations on how I can do that, and only if it is relevant to an investigation of those specific terrorist organizations.
All right, but how is having every phone call that I make to my wife, to my daughter, relevant to any terror investigation.
I don't know that every call you make to your wife...
But you've got them.
I don't know that they would be relevant, and we would probably not seek to query them because we wouldn't have the information that we would need to make that query.
So do I have a reasonable expectation of privacy in any information that I share?
Those are all dependent on the facts and circumstances of the documents we're talking about. In the case of metadata, the Supreme Court specifically ruled that there was not coverage by the Fourth Amendment because of no reasonable expectation of privacy.
Are you getting this, folks? There is no reasonable right of expectation of privacy under the Fourth Amendment. If they decide that you are a person of interest or associated with a person of interest, there's no way to stop this. There's no way to do anything. You are up the proverbial creek. That is how this ball game is being played. They're not going by the rules. They're making them up. The way that FISA was written, the way that Section 215 was written, is not how it is being played today, because it's been amended, but not by the Congress or by the Supreme Court. It's been done by the FISA court. And I'll come back to that. I want to get to Mr. King of Iowa.
Do we have the ability to not necessarily listen in, but track every phone call in the United States? That's one question. Second one, do we have the ability to track any email in the United States? Do we have the ability to track website activity, any website activity in the United States? Do we have the ability to enter into active chat rooms and in real-time monitor? Do we have the ability to track any electronic credit or debit transactions, including the ATM transaction mentioned by the gentlelady from California? Do we have the ability to locate cell phones that are active? Do we have the ability to track GPS locators, whether they're on vehicles or other devices? And then, I know my clock is running down, so I want to pour a little more in here. It's reported by the Obama campaign that they profiled voters with open source data and used that data to target voters for turnout and voter suppression. The IRS has used their search engine to target the president's political enemies. Now, if we can go this far, if all of these things are happening, if the answer is relatively yes to this list that I've given, then I would charge that it would be likely impossible to drive from Bangor, Maine to Los Angeles without leaving a data trail in this country. And all of these things can be justified by the Constitution, by statute, by case law. Am I close, and how would you respond to that big question?
Yes, sir. If the predicate to each of those 8 questions is in the U.S., and if the further predicate is can the NSA, the answer would be no to all of those questions. Is it technically feasible to do some of those things? Of course.
Now, Mr. Scott of Virginia brings up a key point on the question of statute of limitations regarding metadata. The court looks at the application submitted by NSA, who claims it applies to terrorism investigation only, not a criminal investigation. And the response from Mr. Scott, who essentially was getting stonewalled and not getting answers, he just finally says,
I asked you a specific question where if this is available, where is the statutory limitation to what you can get? There is no statutory limitation. You're kind of making it up as you go along.
We're not making it up. We're seeking the approval of the court, and this collection has been repeatedly approved by numerous judges of the FISA court, found to be in compliance with the statute.
Okay.
Now, Scott says this in response to how the government refuses to answer the question about statute of limitations. And the witness denies making the rules up as they go along. Now, finally, we come to the former chairman of the Judiciary Committee, Jim Sensenbrenner of Wisconsin. And I'm going to specifically get into some of what he addresses here.
Mr. Conyers was correct in saying why the relevance standard was put in, and that was an attempt to limit what the intelligence community could be able to get pursuant to Section 215. It appears to me that according to this letter and according to the testimony of FBI Director Mueller, that relevant was an expansion of what could happen rather than a limitation when the law was amended when relevant was not included in that statute. And doesn't that make a mockery of the legal standard because you're trying to have it both ways?
I don't think we're trying to have it both ways.
Well, you sure are, because you're saying, you know, have the court authorized to get us the records of all the phone calls that are made to and from phones in the United States, including people who have nothing to do with any type of a terrorist investigation. And then what you're saying is that we'll decide what to pick out of that mass of maybe 1 billion phone calls a day on what we're looking at, rather than saying this person is a target. Why don't you get an authorization only for that person's telephone records? Section 215 expires at the end of 2015, and unless you realize you got a problem, that is not going to be renewed. There are not the votes in the House of Representatives to renew Section 215, and then you're going to lose the business record access provision of the Patriot Act entirely. It's got to be changed, and you have to change how you operate Section 215. Otherwise, in a year and a half or 2.5 years, you're not going to have it anymore.
And that's the bottom line of what's gone on here. Provisions were provided, and they have been altered and amended, and not by the Congress and not by the courts, but by this FISA court. Clearly, they are making up the rules as they go along. Clearly, they're changing things without public oversight. Clearly, everything that this was designed to do has been altered, and there is a great level of abuse of authority and privilege that has come from this. But what was clear to me that day, and even more so today, is that the executive branch has clearly crossed the line and are being called on it, for the most part in a bipartisan way, at least where FISA is concerned. The responses by the Justice Department and the NSA were flimsy, and that was obvious. Now, the next hearing will be conducted as a classified version, so we may never know what happens. I'm Andy Ramirez. Thank you for watching.